And I haven't seen hardly any of your faces.
Right.
Because it's usually just John.
Yeah, well, Jimmy
John's the
can tell
man.
Yep,
Our
yep.
audio visual isn't the.
Yeah, no, it worked all. I'd rather be here in person anyway.
Right,
Yep.
you're there. So we'll always have one of us here, whenever you guys request us.
Okay.
One of us will always be here.
Ross, I believe it is. We'll give it another minute just to see if Zach comes. Go by the clock on the wall. No, it's.
What? I don't have the mute. We can always either phone. Yeah, here it is. If I can fix that too.
You want my costume mode? Electric light break. So I can take the trans and pick up those metal, the old trans and the motors come up. And the electric motors come up.
Oh, is there?
All
right. What about this one, Ross? There's no signal. I plugged in.
It's not going to, really?
I had it on, then I unplugged and I plugged it back in. But
It was working, you said?
at first I put it on, then I unplugged.
I'm just gonna reset the whole thing. We had that power outage, when that happens, it's just
All right.
like everything that
Your
goes.
plug looks crooked in that box over there, is that anything?
And that one still need to pop on.
There we
There
go.
we go. We got something now.
Maybe.
Maybe.
Yeah, it usually takes a second.
It might take a minute.
I saw it do
just
something.
reset this to warm up.
There we go.
All right, there we go.
Okay.
We got that
Nothing
up.
back here, but, okay, there we go.
Sounds good. It's after 6 o'clock. We'll call the meeting to order. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At first, I do want to introduce Mario Engaged from McKenna, here to join us in person, which is nice for the business items that we'll be discussing. For the agenda, we have approval of the agenda.
Yeah, I'll put it.
We forgot the roll call again.
Any support on the? We have a motion and support to approve the agenda. All in favor signify by saying aye.
Aye.
Those opposed? Agenda is approved. Call to the public. First call to the public will be for agenda items only. Anyone?
Hi, Jeanette McPenna, resident of Tyrone Township. I'm really concerned about the utility scale solar wind and battery storage, the zoning district map. I noticed that in the packet, at least what I noticed, I don't see our current approved zoning map, because until you make the changes and have the public hearing, maybe I missed it, until you have the actual public hearing on this, we have a zoning map that's already been approved, right?
For our zoning map
Yes,
or overlay?
the overlay, yeah.
Yes, there's currently an
Right,
overlay in place.
so there is a current one that is approved, that is in, that is the official overlay zoning district map until and when and if this ever gets, these changes go through. So that's just a concern for me. I think it should be in the package to show people what the current zoning is, because who knows, this may never go through, right? Also, I do believe that you guys should be looking at what other townships are doing. Some are saying, forget it, we're not any longer, we're not even going down this road because of what the laws and the MPSC and what happens when they look at your maps and say that that's not where they want it, et cetera. I mean, there's a lot of different reasons, but I still believe strongly in consulting with other townships and saying, what are you guys doing? And just taking a look at what they are doing. We're so close to so many things happening right now. Hundreds and hundreds of acres that are going to be going under despite what these new laws are coming down, et cetera. It's going to take a long time for anything to trickle down federally to Michigan. That money has already been allocated. So anyway, that's just one thing. And I do ask, where's the roll call? You missed it last meeting, we didn't do a roll call tonight either.
Thanks for your comment. Any other comment?
I don't know, we're gonna discuss where we're at today on the MMA. Okay, so I don't know what we're gonna discuss yet, so.
Well, yeah, that's on the agenda.
Yeah, so like if you get discussion and my son come up.
Anything that has to do with the
Yeah, I'll
MMA.
raise my hand. 'Cause I don't know
Or-
exactly
or-
where we're at. All right,
Okay.
I'll look at it, I'll let something might pop up.
Okay, thank you.
Just have a quick, Paulina Marseille, Hogan Road. I just have a quick kind of comment about marijuana stuff, that people are coming here to this township, or Rennie Township, and I was thinking, why would they did not ask neighbors about how they feel about it? All the big businesses. That should be actually, what happened to it? They will just completely throw it out and we don't just deal with this anymore because the business is just, the neighbors' opinions of how to, conduct and is it. That's kind of my comment about this businesses. Thank you.
Thank you. Any other comment? Hearing none, we will move to old business. Item 1, utility scale solar, wind, and battery storage overlay zoning district map. So, we've been working on this for a couple months now. McKenna has provided us some draft maps based on feedback from the planning commission over the last few months. They were included in the packet. Ross, which one was added?
The
Future.
future land use over there.
Future land use.
Yeah.
Okay, so now we do, in addition to what's in the packet, we have the same overlay on top of the future land use, which we had incorrectly had the future land use map as the old one prior to the master plan on the website, which I think you guys grabbed. So now we got the updated one, that looks good. And I think, I guess, I guess, do you guys want to provide any other input on, or any other discussion on what we've got here, or?
I could just summarize.
You
kind
can
of
summarize, yep.
What has changed. At the planning commission's request, we did remove the northernmost overlay district that is currently approved and in place, but this is our draft zoning map. That northern district was just south of White Lake Road, and it was approximately 76 acres. We have since added a couple more parcels and a portion of a parcel to the other existing approved overlay district just north of Center Road. We've added approximately 94 acres to make up for the loss of that northern overlay and to also add a little bit more. So you have a current total as presented of 364 acres of potential renewable energy overlay. I hope everyone caught that. My apologies. But yes, in short, we removed an approved overlay district area of 76 acres from just south of White Lake Road, per the Planning Commission's request, and added approximately 94 acres to the southern overlay district. It is contiguous with what was originally approved. And then we do have the other proposed overlay area. It's about 183 acres just south of Hogan Road, north of Center as well. And just for your review, we do have several maps showing existing, future land use, zoning, high voltage transmission lines, and sensitive natural features. We did take into account the county's letter. I know that was a concern, quite a lot of sensitive features in that former area up north. This is much more compatible.
Yeah, from what I can tell, I think that the direction we gave you on these parcels, looks to be accurate. Do you guys agree?
Yes.
That's what
Yes.
we provide direction on. I think it looks good. I think the maps look good. We got each parcel or portions of a parcel that's in the overlay. We got acreage for those, and then the total acreage, which, is easy to, see here. So I like where we're going with this. Any discussion from the Planning Commission?
I didn't see, from my perspective, a whole lot we could improve on these. I thought they looked pretty good. So,
What was the recommended acreage that, I know, I asked this question a couple times, and this is me just forgetting again. But what is the recommended acreage that we were trying to go for?
I believe we were aiming for 300.
Well,
I thought it was in the twos.
At a minimum.
Like high twos.
No, from the county.
Don't listen to me.
The recommendations are, it's subjective based on
Sure.
how you feel, what kind of data you're getting or how energy efficient this potential development could be.
Mm-hmm.
But I believe the county's was 300 to 500 for solar.
Okay.
It might have been different for wind, but I think as the planning commission, we had talked around that 300, in the 360, I think is.
and the township attorney that was helping the township,
Yeah.
that number I think was 300 or 320.
Was it?
Yeah. Yeah, it was like low.
For some reason, I
300s.
was thinking it was like high twos, but yeah, I think you're right, actually. Okay. So, even with that being said, we're currently at 364. Is there a reason why we could bring it maybe down to 322 by removing that 42.88 acres right there? The little parcel. I'm just trying to figure out where that bare minimum.
The only problem is that one, I think, that one doesn't really have any other neighboring properties. It's kind of out there in the middle. Really, and another point of this is not all of that 300 is going to be developable. If you look at the map.
Oh, yeah, you're actually right.
If you look at the map
I
for
totally know what you're
the
talking
natural features,
Yeah. Yep.
there's the fact, there's a gas station on this 1.63. I don't think it's worth trying to remove it because it's not adding a lot.
And there's little bits of wetlands.
Then there's the factory next to that,
Yep,
which,
factory.
now, could they add some around their retention ponds or whatever their lagoons are? I don't know what's there. Maybe, but that's up to them. But it's probably not all would be able to be developed very easily.
Right.
So I think where we're at gives us that little buffer,
Yep.
One thing I did forget to mention, but Rich was not here tonight, but he did send an email, and he said, "Hi, John, I can't make this meeting, but I wanted to send you a note to say I'm in favor of this draft overlay for the utility scale wind solar area, and think it is appropriate to move forward with. Thanks." So that's input from Rich.
That's great.
We didn't, we early on talked about another option to have something on the east side of 23 as potential identifiable land. And now that looking at the overlay against the high voltage transmission lines and the additional maps, thank you for including those. It appears there might be some more opportunity just as an option while I was gone, was there any, I don't remember in the reviewing the meeting, if there was other discussion about instead of including this 183 acres to the most western side, but looking at an alternate of on the eastern side of 23 instead. Not necessarily just a question for McKenna, but for the rest of the commissioners as well.
I mean, we've discussed a lot of options, so you know, we have discussed something on the east side of 23. You know, I think, even looking at this map here, that is the draft renewable energy overlay in existing land use, you know, you can see that, you know, the gray area is vacant, you know, which is gonna have, in my opinion, the least impact to residents. And, you know, taking that into account, you know, you look on the east side of 23, and a lot of that is that land use of that light green color agricultural rural residential. So I think, you know, it wouldn't be a bad option, but I think where we have it now is providing a good, you know, location where it's going to impact residents minimally. You know, there is some, you know, you look just east of 23, but kind of adjacent to where we currently have, you know, the industrial area in this section overlay. I mean, there's some there you could potentially add, but I don't know if it's worth it, or, I mean, or other areas. I guess we're open to everything, so if there's a parcel or a section of parcels that we want to look at, I think we're open to it.
So one of the things that I've heard other townships discuss was the fact of, you know, it doesn't matter if somebody is living here, it doesn't matter if there's a parcel there. If it's zoned appropriately for it, right, they can go to them and say, hey, listen, we'd like to buy your house, right? And so, you know, I thought about that, like when I believe I was one who suggested, you know, looking on the east side too as well. You know, what does it hurt any? I mean, at the end of the day, the individuals are gonna say, yeah, I'll buy it. Or they're gonna have to sell a bunch of them in a row to actually make any sort of, you know, legitimate amount of, to make it worth their money, right? Yeah. And so.
Purchase or lease.
Yes, correct, purchase or lease. And so, you know, one things that other townships have been doing is setting up that way in those residential areas and saying, hey, you know what, we're giving you the acreage, you're gonna be the one, just because it's not developable now, you're gonna be the one to be able to go forward and say, hey, you know what, you're gonna have to go and talk to those individuals and see if they wanna sell their property, right? So that was just one of the things that townships, that I talked to a township official, and they told me that they were going that route, and seeing if the, you know, if those guys are gonna bite, but no matter what, they still have the allotted amount of land in there. So just something that was kind of the reasoning behind the idea when I had mentioned, let's check on the east side of the road too.
If the map, the current proposed map, the first one, is approved to move forward, does this go then to have to go through a public hearing, and then we have to notify all the residents who would be impacted and surrounding those
300 feet of any property.
that's proposed again, so we would know, we would be able to see the list of owners of that land, or people who would be impacted and things of that nature before the public hearing, right?
Yeah, if they're within 300 feet of the property boundaries, they receive notice in the mail. It's also got to be published in the paper, just like any other public hearing.
Okay.
And to be clear, I also support this draft. Like I would echo Rich, and I completely actually support this draft of what we have right now. I like to try to minimize things, but yeah, you made a great point, John, when when you stated, hey, you know what, not all of it's developable. Right?
Yeah, so I think we don't wanna, if a recommendation from county, our attorney says is like 300 minimum, 300 to 500, we're talking. You know, we wanna give that little bit of buffer, because not all ours is. There's small wetlands in some, you know, there's some buildings in some. So I think we've got a good amount.
I mean,
I'm
what's the next
happy with
step
the
here?
amount.
I am too. What's the next step? I mean,
If you're all happy with it, then the next step would be to hold a public hearing.
we could hold a public hearing, and
We would want to make that motion at the next regular.
I was gonna say,
yeah,
we can't
I was
do it
gonna
now,
say,
yeah.
that's not an official motion, right? But I would like to to be at a regular meeting.
Yes, because this is a workshop, we're not making the official decision.
But to move forward to a public hearing, we don't even need a vote on that. We can
No,
just
but
give
we're
it,
not going to make the deadline for the April meeting, given the,
anyway.
yeah.
So, when we have the next regular meeting,
Unless we were to convert
the plan is once the whole planning commission's here, we'll have a unofficial vote to, hey, send this forward to a public hearing.
I do have one other question, if I may.
Yes.
Mario or Gage, do you know specifically what areas of the county recommendations were not applied to these maps that you guys have put together for us?
I think the primary concern from the county was the sensitive natural features, and that took up a majority of that northern overlay area. Moving it down here, like what was mentioned, it's more vacant land, more agricultural/industrial, and it's not covered by sensitive natural features. I think that was the primary concern. Everything else, can't speak to too much, but I can definitely comb through and let you know if that's.
One thing I can think of, Chris, that we didn't necessarily address is the factory and the gas station. We still have them in there. We had them in our future land use plan as industrial properties.
Sure.
And that's kind of how our first overlay draft became. We said, well, if it's industrial, we'll just put that in the overlay and that's it. And then obviously we got comments back and stuff, but they mentioned a lot about that in there. But you know what, like I said, that, you know, if you look at the factory, for example, you know, there's some area where maybe they could squeeze in some solar panels. And you're mixing the use then, right? You're not, so I think it's not really worth removing it, you know, in my opinion.
I wasn't.
The gas station, on the other hand, it's like, you know, that's 1 acre. It's like, we could remove it, but, you know, I don't see
Foster
it's gonna
Swift
help.
recommended we don't go to that level.
Yes, exactly.
They said to keep it, they said they don't really care where you put the land. Our job isn't to make it easy for the developers.
Exactly. And
It's just to provide the best reasoned approach to picking the areas to include.
Yeah.
That's what I recall Laura
We did,
from Foster
but we
Swift.
we kind of did improve, we did take some of those comments that they had and did make it easier by having some more of this vacant land where up in the northern district, you know, the concrete plant and surrounding area, if someone was actually able to try to develop this, yeah, they would have a lot of clearing, it's uneven land. So we removed that. And in my opinion is, we wanted to remove that because of the sensitive natural areas, not because it was difficult for the developer. You know, that's
Right.
my opinion, but they had opinions on that about the distance to the power lines. Once again, that's, in my opinion, up to the developer to get to, but we did, you know, we got pretty close, you know, so it's really hard looking at this power line map. There's not much areas in the township that are far away, but I don't really see that as a really deciding factor for the interest of our township.
Sure. Thanks.
Any other discussion on utilities scale, wind, battery storage, overlay district map? All right, sounds good. We'll move on to old business item number 2, Michigan Medical Marijuana Act, caregiver regulations.
Oh, I apologize.
Yep.
Just the last question was, the future land use map from the master plan was not put put against this overlay, right?
It's in your packet, but it was
But
included
it's
today.
separate, okay.
It was included today,
All right.
so that's why
That's why
I
I'm not
mentioned
seeing
it
it when I
first.
print-
It's
okay,
not in the
thank
packet, online or in the email,
Thanks.
but it's, Ross gave us his hard copy now. And as you see in this one, it's the correct future land use map, because we had the incorrect one on the website. I assume the website's fixed, I haven't checked that,
Not yet, it was.
but please get the website fixed, or,
Just updated on the packet. We'll have it in the.
Yeah, I'll go look at it afterward, nothing.
We'll have it in the packet for the next meeting anyway.
no, but I meant the website fixed for the future land use
Oh,
map.
that
So
is fixed.
That's fixed, okay. I haven't checked that one, but, it led our planners astray, so let's, developers and stuff, we made some big changes in there. So we want people to look at the, current one.
All right, thanks, I won't interrupt anymore.
No, that's fine, all right, so, Michigan medical marijuana caregiver regulations, I think this one, Gage, if you just wanna start with, and I know it's, actually, I didn't see it, but we have a schedule too, so you can give us your summary, and also, we can talk the schedule afterwards, but
Sure.
at some point, let's discuss that.
Yeah, I'll go over the proposed amendments. So before you tonight is proposed amendments to the zoning ordinance with regards to caregiver operations, sometimes called caregiver grow. I think one thing to keep in mind for the residents is to understand, just for the lay of the land, that the township has actively opted out of adult use marijuana facilities under the MRTMA, the Michigan Marijuana Regulation and Taxation of Marijuana Acts. So the township is completely out of adult use marijuana.
That's
to my
recreational?
Correct, recreational, yes, better known as recreational.
Like a dispensary, like
Right,
stores,
exactly.
yes. All right.
Yeah, so the township has completely opted out of that because under the state statute summarizes MRTMA, the local municipalities are required to actively adopt an ordinance to specifically say you are opting out, and the township has done that. Similarly, well, somewhat similarly, but with the medical marijuana facilities, there's an act adopted in 2011, for the Michigan, the Medical Marijuana Facilities Licensing Act, or MMFLA, and in that act, that's the regulations at the state level for facilities, large-scale facilities and facilities for the commercial grow, processing, and sale of medical marijuana. Now that, within the statute, it specifically says the state cannot issue any license for a facility unless the local municipality has adopted an ordinance that allows those. And the township has not adopted that. We don't have any on the books any ordinance on the books currently for that. And so any facility under MMFLA is not permitted in the township either, for everyone to be aware of that. So the
What
key.
kind of facility is that?
So when it comes to those, that was a stopgap. Well, that was a reaction by the state legislature in about 2011, because after the adoption of the initiated law 1 for medical marijuana, one thing they found, and as per planners we understood, that law was very, very poorly written with regards to allowing for facilities. That's why you saw at that time a lot of different communities dealing with it in a lot of different ways under the Medical Marijuana Act. So the state then subsequently adopted the MMFLA, specifically allowing facilities. So commercial scale grow facilities, they had created a different category for any facility that wanted to do processing of that marijuana, typically to create any kind of edible or any kind of other type of product. And then also they created separate licensing requirements for transporters of that marijuana between facilities. And then they also created a separate requirement for what they called a provisioning center. So in order for any person to obtain marijuana, medical marijuana for their use, they had to go into a provisioning center. So those are the scale facility, those are the they're a retail storefront. But at that point, if someone has a medical marijuana facility provisioning center license, the only thing they can sell is medical marijuana to someone. And so those facilities, once again, are only allowed in a community if local regulations were adopted, and the township has never adopted those. So those large-scale facilities are not permitted in the township. So what we're covering tonight goes under the initial act created by, that was adopted as a result of by adoption of through the election process, and it created the Michigan Medical Marijuana Act. So that act is the one that it was very poorly written in terms of from a planning standpoint with regard to facilities. So you had facilities everywhere. One of the key aspects of that act is that any person that receives a authorization from a doctor for any type of illness that needs medical marijuana, they become a registered qualifying patient. And then that patient, in theory, then under the first statute, is allowed to grow up to 12 marijuana plants for their own personal use. The statute also then allowed for the creation of what they called a primary caregiver. So so that person has to be registered with the state, obtain a license from the state to be a registered primary caregiver. These caregivers are allowed to assist a qualifying patient with growing their marijuana, and there are other tasks that they're allowed to assist with. Because the idea being, back in the day, the idea was that, marijuana is potentially beneficial to certain people with certain ailments. However, not everyone has the ability to grow marijuana for themselves or obtain them on themselves. So back then, they said, we'll have these caregivers. Now, that was back when this was originally established, and so there's all kinds of different type of ways in which caregivers attempted to grow, and it was even sanctioned by the state at some point. So what you have on your books right now within the zoning ordinance is regulations with regard to caregiver operations, meaning a caregiver attempting to growing marijuana and doing other activities to assist qualifying patients. The key to this was that eventually, because it was so poorly written, there was a lot of these regulations at the local level that were just never clarified until the Michigan Supreme Court finally ruled that, in fact, yes, local municipalities under the Zoning Enabling Act have the authority to regulate where these can go and what they can do. So that's why before, caregivers, with the register with the state, they were growing marijuana everywhere. They were growing in houses, garages, everywhere. And so local municipalities had to develop ordinances to try and regulate them. Some were effective, some not. Now, with the Supreme Court specifically saying that, yes, zoning laws still work for the regards to these caregivers, we're allowed to specifically regulate them. And so under this, I don't know if you can tell, but I've had kind of extensive experience with these facilities over the years. And one of the aspects of them that I've been successful with is making sure that these caregiver grow operations get out of residential districts. There is a strategic approach that municipalities can do to make sure that caregivers no longer grow in houses, they no longer process in houses. A lot of times if they're doing things without proper reviews and approvals, they can cause a damage to the facilities. These facilities draw a lot of electricity. Sometimes in more dense neighborhoods, they can cause brownouts in the local area. And so from what I've heard, it sounds like a lot of that has occurred throughout the township, or possibly. So the idea will be with these amendments tonight, these amendments are proposed to focus on the zoning aspect of caregiver grow operations, or caregiver operations. And so some of these standards might seem a little more lax than what your original ordinance is, but that's only because those are the rights granted to caregivers within the state statute. So we want to make sure that this ordinance does not violate any authorization granted to a caregiver by the state statute. For example, the idea that they can technically they could process marijuana to create an edible for a patient. That's actually within the state law, and so we can't prohibit them from doing that. But there are also, within this ordinance, there are specific approaches that I think are important. Number one being that caregivers, first of all, they have to be registered with the state, and then they can only grow and assist only up to 5 patients that they are connected to at the state. So they can only do that for only for 5 individuals. So 5 individuals, in theory, they could have 12 plants allowed for each one. They could have, plus they are allowed as a caregiver, if they have their own qualifying license, to have grow marijuana for themselves under the MMMA, the original for medical. So therefore then they could have up to 72 plants. So I don't know if you ever heard that number, but basically that's like a common thing that everybody says, oh, caregivers can have 72 plants. They can when they follow all the rules and get all the registrations and everything. So needless to say, that's like a specific requirement of the statute that is built into and specified within these amendments, saying that only when they only can grow marijuana when it's specifically for a patient in which they're registered through at the state level. So in my opinion, that's one aspect of that, is that they can't then just have 72 plants and hop around with different patients and have supposedly this number of marijuana. So it's one good aspect of it. Then it doesn't become a business operation. It becomes what it's intended to be, providing medical assistance to a specific number of people. So that's just one aspect of these amendments. The other key aspect to this approach, well, 2 things I want to point out. Number one, on the cover memo, I'm just letting you know that the last law that was adopted, the MRTMA, that does allow any adult within the state of Michigan to have up to 12 plants on their property if they so choose. The way I interpret the law, they can only have 12 particular property, but it's for the lawyers to decide if each adult gets 12 or if it's just per property. I think it's just 12 per property. So the issue will be, when we go through this process, even though we will we will require caregivers to be located in a certain location, technically any person, any adult, could have 12 marijuana plants on their property. Now, they are required to have it in an enclosed locked facility. It can't be visible from public right-of-way, that sort of thing. So while we'll be able to reduce the number of plants on a particular site, the MRTMA gives people, even in a subdivision, the ability to grow up to 12 plants.
And that 12 plants, that's recreational, and we're not talking about that.
Correct.
And we're not, that's, another point of that is, you can get 12 anyway.
Right, exactly. That was my main point. It's like, you can get 12 anyway, and it's just that and the reason I got to that point is that I heard I believe your concern was that having marijuana grown in residential districts, it was becoming a nuisance. Well, while this approach can deal with more than 12 plants, people can develop 12 plants anyway. So the other aspect of this I wanted to point out is that, getting to the point of our approach, is it has to be a 2 ordinance approach to this. One, the zoning ordinance, which was specifically in front of you tonight. The second will be the creation of a regulatory ordinance. So that would be a licensing ordinance that would require caregivers, if they want to be a grow operation, they would have to obtain a license from the township.
So we talked about that one last time.
Mm-hmm. And the key to that is going to be that one of the requirements of the license will be compliance with the zoning ordinance. And the zoning ordinance will specify where they can grow. So we'll put in sunsets and we'll put in the specific requirements in the licensing ordinance. And a lot of the language you see tonight that might be struck out from the zoning ordinance, that's very good language. It'll be incorporated into the regulatory ordinance. So that's good language that'll be included. But the key will be that once this is enacted, once both ordinances are passed, then a caregiver will have X number of days to register their location, to obtain a license. And if they come in to obtain a license, they will be required to be in a specific location. If they don't have that location, then then they can't operate in those other districts. So more specifically, caregivers would not be able to operate in residential districts. So So before you tonight, so sorry for that long introduction, but I just wanted to get the lay of the land for everyone to understand what the very fine, very hoop we're walking through is specific to this. But I have found that it's very effective in getting caregivers out of residential districts. So, as I mentioned, just briefly, going through the ordinance proposed amendments, a lot of the language that's being struck out is because it's more dealing with the operations or the license requirements of a facility, and that shouldn't be in a zoning ordinance. A zoning ordinance deals with the location and then the specific requirements of how the site is developed. And so any caregiver would have to make sure to comply with those standards. And then the licensing ordinance will go over specific things with regards to that, obtaining a license. So we've left the purpose section. We've made sure that the prior use section stays, meaning that if someone was operating prior to the ordinance, they can't claim legal nonconforming status. I would want to, since that's already in your zoning ordinance, I presume that this township attorney has confirmed that's a viable designation to include. The definitions were modified to be consistent with those definitions in the state statute, including having a specific definition of marijuana, and then the caregiver operation. Under the new number 3, medical caregiver operation, it specifies those tasks that a caregiver can do at a facility, and then medical marijuana. And then the ordinance, once again, focusing on zoning standards, we explicitly state what is a permitted use on the site and also what is prohibited. So the specifically permitted uses are a primary caregiver can cultivate, manufacture, extract, possess, or transfer marijuana, marijuana-used products, or paraphernalia for no more than 5 qualifying patients to whom they are connected through LARA's registration process. So that kind of focuses them on their business operation and what they're allowed to do. And then one way that this will work in tandem with the licensing ordinance, the licensing ordinance will require that the caregiver keep on file with the township those individuals they're allowed to grow. And if they change, like say they want to try and say, oh, I'm going to have this patient one week and this patient the next week, they can change their patients as long as they first register them with the state. So I'm afraid I'm not familiar with the state's registration process, but at least they have to go through and register those patients with the state and then provide a copy with the township. So that's one of those things to keep them honest with regards to whom they're growing this marijuana for.
Is there anything additional that we can do to kind of help monitor that a little bit more, like to tighten it up?
So
versus just like, hey, it's at the state level.
No, well, that's why a key aspect will be that they have to provide copies of their registrations and their relationships to the township. And I will admit I'm not as familiar yet with all of the enforcement abilities that the township has. So working with Ross, we'll make sure to designate within the ordinance that particular individuals and that particular task with someone that can more closely observe these and be responsible for maintaining the records at the township level. Because you're right, that's going to be a key aspect, making sure that we're on top of this. Because when it comes to enforcement, if something happens where they're trying to use the enforcement, a key aspect will be being able to tell them, look, you're only with these 5 individuals, where their copy of their registration cards. If you're in violation of that, then in theory their license could be revoked because they didn't comply with the license requirement. And so even if they're in a facility, bad operators, their license can be revoked. That's a key of a licensing ordinance. So having that data on file is be important.
When it comes to as far as like the 72 plans goes, when it comes to the registration of those individuals through LARA, can these individuals be registered to multiple caregivers?
No.
Okay.
That's the key, is that they're only one patient is only allowed to register to 1 caregiver. Right. So that relation is supposed to be, yeah, exactly.
And then what is the process like? we've had, as I said, we've had problems here. What is the process as far as to prevent caregivers who do go over 72 plans? Because, I doubt the state is looking at them on a regular basis.
That's correct.
Right. And I know it happens.
So unfortunately, then the burden does fall on the local municipality and the local municipality's enforcement tools.
Okay.
So
That goes back to, enforcement then.
yeah, and it does. And in the end, once again, we'll create these ordinances, we'll give the tools to the township, but then and honestly, even for enforcement officers and even for different type of municipalities and different cities, like I've worked in cities where they do this, it's kind of hard for enforcement officers to walk around and patrol for something like this because they tend to be within, they're not operating out in the open.
It's gotta be in a locked facility.
Right, it has to be in a locked facility, but also these caregivers, when they have more than 72 plants, number one, they don't want to broadcast it, but also number two, that's a big investment for them. So they're not trying to let other people know where the marijuana is. So the burden kind of does fall onto the residents to make a complaint about that. But that's only because, but there are definitely other tools that could be used by the township to deal with them. For example, I mentioned the electrical requirements of these facilities. If you're growing more than 72 plants, typically do you require more than a standard 200 amp service to a facility, to a home? A lot of times they'll come in and apply for, if they do it the right way, they might apply for a electrical permit to install another to a higher voltage, a higher amperage service. DTE doesn't care because the electrical company just wants to sell electricity, so they've been allowing these. But if we wanted to, we could also change the electrical permitting process to specifically say anybody that applies for more than one single service has to indicate what that is for. Sometimes as needed, if you have an electric car or something like that, or something to that effect. So that's one tool. Another tool that some communities use explicitly is in tandem with the electrical is an additional. I don't know if it's a rule or a policy done by the fire marshal that would then have another layer of local requirement that could protect and allow the fire marshal to shut something down immediately with regards to if they have any kind of caregiver grow. And I can make a note to research that a little bit more because honestly, these ordinances that I've been working on have been effective. Most of my other municipalities haven't utilized the fire ordinance regulations, but I can look into that to see that as another tool. But the issue with that enforcement is just the nature of the use. It's unfortunate, but it's true. You can't really know what's going on within a structure until something happens or someone becomes aware of it, and they tend to be very nondescript about this. So unfortunately, that's the only thing. There's no way to really gauge that.
So I'm jumping ahead a little bit, but it's relevant to the conversation. I like the language about, wastewater, odor, security, and stuff like that. And that's a similar, sort of issue in terms of how you enforce it. I assume the actual enforcement mechanism would be in the licensing ordinance rather than what we're looking at tonight. Am I right about that?
Well, that leads to some of the questions I would have for you, because these are, once again, all zoning requirements, and right now, the caregiver operations require special use approval at the township. Our recommendation, so that's a benefit because then any person that does want to establish one would have to go through a public hearing. And so everyone within 300 feet would be notified of that request to be a caregiver operation. The one issue I find with that is that then it's a use that runs with the land. So as soon as that's granted, it's there for, at least in my interpretation, in perpetuity.
everything for the special land use is followed, right?
Right, yeah, that's the other thing, that's what I was gonna about to mention, that, yeah, the way your ordinance is written, it does specifically say that that right is only granted, is only maintained if it's, those conditions are met. So if you've had success with that approach, then that's probably the best, because that's a belt and suspender situation where you have the public hearing, they have to go through the special use approval criteria, and then if they violate anything, then that right goes away, so that's best. Other communities don't have that type of criteria for the special land use. They fall on the other side of the discussion that says it runs with the land in perpetuity. So then that's why usually, to get to your question, is that they still have to get to site plan approval. So any of these facilities moving forward have to have a full-blown site plan. So they would be required to come in, have a full-blown site plan, and meet odor, wastewater, security, enclosed lock facility standards on a site plan, stamped, sealed by a professional. You know, they would have to go through and do this. And then one other aspect I think is key is that other communities tended to allow for more than one caregiver on a lot, on a particular piece of property. I'm recommending that you only allow one caregiver on one lot. So that's just to, because.
One caregiver per one parcel, per one special land use.
Right.
Would there be any reason we couldn't require them to, and admittedly, you know, their information might not be the best information, but could we proactively require them, I don't know, monthly, annually, whatever, to, you know, give us data or a certification that says we're in compliance with wastewater, we're in compliance with odor?
So at a minimum, your licensing ordinance, the licensing ordinance can require them to renew that annually.
Okay.
And at that point in time, we can include that. I'll make sure to note that. Include, make inspection for compliance with all zoning standards. Yep.
Yeah, third party picked by the township, not by the caregiver.
Oh, absolutely. Yeah. Yeah, like any kind of inspection, yeah. Yeah, in theory, depending on the attorney's opinion, we might be able to do, you know, have it more frequently. One thing I would recommend is, well, and it's already in there, in addition to annual inspections, the township reserves the right to hold inspections at any point in time. So if there is a complaint received, then the township can hang their hat on that particular part of the ordinance and go in and do an inspection. And the first thing they can do is, give me your 5 patients' records and a copy of their registration, and making sure they're all compliant with the state and odor, wastewater, all those other aspects that could be triggering.
I would want to ensure, though, that the wastewater and odor specifically could be a random test, so that there's not anything scheduled where things could be hidden. So if the township desired to do a random test.
Or a test whenever we choose.
Right, random that we would choose.
But not random, because we want to get it when it's the most smelly.
Well,
But
true,
not when they determine.
But not when we
determine.
The point is not giving them time to.
Yes.
Mitigate it
To
or
stop
something.
operation.
Cut all the plants down and
exactly.
then come at the
Right,
week
same,
later.
yeah.
So we'll have to consult with the attorney, because I believe, I know under the building code, you're not allowed, you have to give them some kind of notice for building code standards. I don't know if that also applies to this, so that'll be a question we'll have. Another thing is we'll have to determine, usually the approach is you allow them some opportunity to mitigate the issue. And I don't know, I'm not an attorney.
You
so I
mean
don't.
before violation?
Oh, no. Once an inspection is held and then a violation is found, in theory, you do give them a certain number of days to comply, or then their license is pulled. Once again, I'm not an attorney, so I don't know if that's a requirement, or if we can just say a violation results in immediate removal or revocation, I should say, revocation of the license. I will have to research that as well and see if we can put that requirement in there.
If we couldn't revoke immediately too, I would think, and this is not my area of expertise, but I would think that we could have something that says if you violated X number of times within a given period of time, your license goes away.
No, that's a good one.
So,
3 strikes and you're out, or
Yeah.
2 strikes and you're out, or whichever. Yeah, no, that's a good one.
So I would like to see something tightened up on the caregivers. So, for example, say I own this. What would stop me from registering the 5 people? And then, well, I changed their names. Pretty soon I got 10 or 15 people coming in.
Well, that would be a violation of state law and a violation of
No,
our
but I mean,
ordinance.
how could we protect that?
So that would be something where, you know, the ordinance requires, and will require caregivers to provide those records. And those 5 people that they're actively helping have to be on record with the township. And then if they change it, then they're required to come and tell us that they've changed it. And you know, the one thing about multiple people is that they want to be able to grow more than just the 72 plants. Now, some of them might do as you suggest because they want to, because you know, I read these ordinances, but I don't know exactly. Like someone told me one time how many, you know, joints you can get from one plant. I was really surprised. But I don't know specifically what that is. But if it's true, those numbers they were telling me, then chances are, yes, they're going to generate so much marijuana from those 12 plants that they're going to want to, that it's going to be go beyond the need of one patient. So yeah, then they are looking for patients, 6, 7, 8, 9, and 10. If that's the case. So then from their business enterprise, they might want to try and have more people rotate through. You know, it's hard to know, you know, that day-to-day relationship and who they go to and who they provide the marijuana for. We can have these requirements that they're only required to that, but until, you know, that's not something from a zoning standpoint, even operations standpoint, we can constantly monitor, you know, because that's just a one-on-one relationship. So it'd be hard to like try and get in between that. We can do as we're doing, require that they only have their relationship with the 5 people, and when it changes, they have to tell us. But if they're literally out the back door talking to patients 6, 7, 8, and 9, you know, that's something that unless, and I'm not a police officer, but I would imagine they might say that, you know, until you catch them in the act of giving them to patients 6, 7, 8, and 9, there's nothing we can specifically do about it. From a zoning standpoint, we can restrict the location, we can make sure they comply with state law, and we get them out of residential. But we can't, but beyond that, how they operate, if they're a bad practice person, in the end, they have to be, you know, eventually, for lack of a better term, caught in the act.
So that means if their patients are registered with the state, it would perhaps be better in the licensing area to put that those patients are actually living, for example?
Well, yeah. I mean, I don't know.
Doesn't their license go void if they die?
Well, I mean, that's the obligation of them to update us with any changes.
Yeah.
But I don't know what the state law says with regard to when someone's deceased.
Right.
Or dies as a patient, then, you know, I mean, we have plenty of systems in our country that cleaning the rolls, so to speak, is a very weak area. I mean, I'm just...
Right, and you know, in that normal process, the death records are rotated through different state agencies. That's normally how it's done. Whether that happens or not with the CRA, Cannabis Regulatory Agency, and that's their current name. They keep changing it. Whether CRA still is part of that process, I'm not sure. And it points out that, yeah, we are also reliant on the state for that, for some of their processes. And
Sure.
And then also they create separate rules. So the LARA and then CRA has the ability to create these rules to deal with those kind of issues. But whether they do or not, it's up to them, unfortunately. I mean, it's up to them as to whether they, how much they monitor it. So, getting back to the zoning aspects of the amendments, Right now, based on your previous discussion, just a placeholder at the moment, paragraph X talks about the location where these would be permitted. And right now, we have B2, M1, or M2 zoning districts would permit them. But one specific requirement I've included that I think is very important is to have buffers from these facilities, so that way you don't have a concentration of them. So you can have separation from other operations, so making sure they're not directly adjacent to each other. If we wanted to, we could increase that or require a minimum separation distance between the lot lines of them. We also have a residential setback that caregiver grow operations we have to be at least 500 feet from any residential zoning district, and then also from any school or childcare facility. So any school under this, the license under this, covered under the School Act, or any childcare facility that's registered with the state, has a state license, they would have to be at least 500 feet from the property lines of those locations. It's paragraph F. And then other aspects have been kept in here, like the property control, ensuring that, enclosed lock facility, that's consistent with the state law, so they are required to do that. And then I have added, as noted, the wastewater requirement, odor, and security, because those are specific aspects of marijuana grows that can be negatively impacting adjacent property owners. So we want to make sure those are addressed during site plan review.
One thing that we had talked about in previous site plan reviews is, and it kind of goes to caregivers, is like deliveries or pickups, or who actions to say. Can we regulate that?
To the best of my knowledge, it's not something you can regulate because the state law specifically says when it comes to transporters under MMFLA or MRTMA, so adult use marijuana between the retailers and the growers and everything like that, and then the transporters that do the medical marijuana from the facilities, it specifically says that a municipality can't stop them from traveling through their municipality. So if they're traveling from Flint down to Ann Arbor, you can't prevent them from driving on 23. Similarly with this, I don't know of any case law with regards to this, but the intent of this.
Doesn't it go to zoning too? Because, like, say, if you only have 5 caregivers or 5 patients, you don't need a huge parking lot. But, most site plan reviews we do, you analyze how much business is coming in and how big the parking needs to be and stuff like that. So, like, it seems like we should be able to regulate that. But also, I think we should also, we've discussed before in other special land use applications, not allowing the patients to pick it up. So maybe that's.
Well, our current standards have delivery required, so.
Right. And that's one aspect that right now I have.
It's still in there.
Yeah, well, that's one aspect I was going to say. Right now I have removed, because I'm not sure if the state law says that that a patient, because there's certain sentences in the state law that says the patient can have access to their marijuana.
But are they required to have access?
I believe it doesn't explicitly say shall be required, but it does say that they can access it. So, I'm erring on the side of caution with that, because I wouldn't want to allow it to that one little requirement to then suddenly be stricken from the ordinance in the future. But whether somebody would strike that or not, they'd have to go through a pretty long effort to try and get that removed.
When we talk about some of these things that maybe is not 100% clear on the legality, we're going to kind of work through this and then bring that back to, say, Laura or a different attorney of some sort.
Yeah,
Chuck, okay.
Yeah, I would highly recommend.
I'm not choosing an attorney, but whatever the township says, but maybe we keep like a list of those things that, hey, we got to check in with the attorney on this and that.
Right, so exactly, and so I would say if, in the way I deal with it when the ordinances is about whether turning things up or down in terms of like how restrictive you want to be, or how, I shouldn't say restrictive, how specific you want to be with the requirements, or how much you want to just err on the side of caution. And so definitely I would highly recommend, the township attorney has to look at this. And then these type of questions, I would suggest, we can keep a running list of these kind of legal questions, and then hopefully the attorney would let us know how much leeway we do have in the ordinance and how much more we can ramp it up. For example, I picked 500 feet just because that's a little bit more of a modest requirement, but I know from my experience with other regulated uses that 500 is a setback that is protected under case law. I mean, sometimes you can go 1,000, even 1,500 feet as a separation. I've done 1,500 before, but where the attorney is like a little nervous about that number.
Yeah,
Sometimes the attorney is like more like 1,000 or something, but I've had communities where I have adopted 1,500 as a separation, and then so far so good.
So don't they have 1,000 feet for like alcohol to a church?
I believe so, is that? I think that's correct.
In a school or something?
Yeah, something like that.
Like
Technically, they measure a little different than we do in here. I measure it from for lack of a better word, it's just the crow flies. Like it's definitely from
Property line.
Exactly, from property line to property line. The closest point of one property line to the closest point of another. The Alcohol Bureau does it from door to door through the streets.
Driving down the road.
Drive down the
You
road.
could be right next door, but you gotta drive all the way around to the.
Right, if you have to do that, that's a benefit. But then,
Yeah.
but then it works the other way, where
Yeah.
like if it's, So right now, but from a zoning standpoint, my experience is it's definitely best to have property line, because then, because other aspects of this don't travel down the street, such as odor. So, you want to have that separation from schools and residences and residential property, not just the residential structure. You want to make people can be outside in their backyard and enjoy their backyard and not have to smell marijuana. So.
And Mario, you don't, in section F, number 4, you don't call out specifically bus stops. Could you add that? Is that addable? I think.
I'm not sure. I can check into that and see if
Yeah.
that's a possibility.
That'd be a good one.
I mean, you've listed a number of things that are very important, but
Although a bus stop is generally at a residential property, but I don't think it needs to be, It could be like a
They
community
change
bus
that
stop.
frequently too.
Yeah.
Yeah.
Each year.
Couldn't hurt to add it.
That would probably be a question for the attorney to how defensible it would be in terms of that. But, I mean, it doesn't hurt to ask. We can actually try. Those are the ones that I can specify based on their license or their state law or something like that.
14-hour workday limit, 11-hour drive limit.
Excuse me.
Sorry about that.
So, that's the highlights of the proposed changes as related to the zoning aspect. As I mentioned, the licensing ordinance, we can get that language drafted up and prepared for the township quickly. Working with Ross, we'll see, to start coordinating with the township board, because the general law ordinances go through the township board, so they will have to be looking into that. And coming back around to the discussion of the schedule, the township has the moratorium in place. I believe it expires in June. So the intent was to try and make sure that have all both ordinances adopted by May. I'm not sure in terms of your the public hearing requirements, like your policies, if you want to have the schedule of the public hearing be requested by you and then hold the public hearing and that sort of thing. So we might get a little closer to June with this, but I can work with Ross on it.
Yeah.
Yeah, and we can extend it as
necessary.
necessary, yeah.
We'll keep working on it in every meeting. We've had it on our agenda. It did look like maybe we're starting to get a little behind, but I think we don't want to rush it,
can
But we
you check
can
that against the date of the moratorium expiring, though, just to make sure we're,
June 17th.
Yeah.
but, yeah, if that needs to get,
After the June meeting,
right.
the second Tuesday.
And then,
Oh,
with
that's
that,
true.
we
Yeah, we
just
can-
want to give the board a heads up.
We're just talking about that today. We have a
Okay.
list of all of them, keeping track. making
So,
sure
it's not like they got to rush a meeting
Oh,
to
yeah, no,
put a new one in.
We're on top of that.
All right, that's good.
Mhm.
One general comment, on here. This is very good. I really like this here. Original text from, proposed to remove, strike line red, blue text is new, and then the final version with no markups. That's very clean, nice.
Thank you. So so we've taken notes on some of the questions we have. We have some work to do. We'll go and make sure to get that additional research. We'll work on the ordinance, the general law ordinance, and coordinate with Ross about working with the township board and get that scheduled. And if there are any other specific issues or changes you have, like I don't know if you guys have marked up the text in front of you, but if you have any of those, feel free to provide them to Ross or directly to us so we can make those changes, because we'd like to get in front of you an ordinance that you're comfortable with so you can hold a public hearing and make sure that this gets on the books, as long as you're comfortable with this approach.
Page 1.
Yep.
Just a clerical error.
No, that's the thing. I wish I could tell you that I put that in deliberately so you could find it, but I didn't. So,
Did you see it? All the way down?
and the first page of the,
Well, yeah, first page,
Page 1,
all the way down.
it's, it says court of, or a lower court decision. It looks like you
This is
deleted an
coming.
R, but once again, that's a good way for us to see the red line, I think.
A coot, yes.
I thought you were correcting,
Supreme coot.
I thought you were correcting a previous spelling error, but it was actually probably just somebody
Yeah.
accidentally pushed delete or something.
I've learned a term from a clerk now that I like utilizing is a Scribner's error. It is a Scribner's error, meaning that, yeah, it's, sometimes the things, though, sometimes the spell check doesn't catch that, but thank you for that.
And along those lines, in the first sentence of the purpose paragraph, I think it's the first sentence. It's kind of a long sentence, but there's a little bit of what I think is an over deletion there. You've got "and to regulate the conduct" deleted, and it just doesn't read quite right with that removed.
Oh, okay, yeah.
So,
Just conduct activity.
Yeah, and sometimes then you can always go back and read the
Yeah.
full version and read it.
the clean really
Clean
does
version,
help.
Yeah, I really
Yeah,
like it.
yeah.
Okay.
One overall part I don't quite understand, or maybe I don't understand what the direction we had given Gage previously, but the licensing stuff is gonna be a regulatory ordinance. Gage presented that to us. I think maybe as an option, do we wanna go that route to have the regulatory ordinance for the licensing? If I remember, maybe you guys remember, but we talked about like the township licensing things, like we don't have any licensing now, right? So is that,
Yeah.
that's something I don't know, like, is that gonna be like a big deal for now, the township? Pretty small township here, are we gonna have this whole licensing bureau or something, like,
Right,
is
no,
that an
I.
issue?
No, that's a very good question, because I would like, yeah, because as I mentioned, this is an approach that where the local municipality, unfortunately, because of the situation, that burden does have to fall on that, and because this is the approach we found that works, the two ordinance approach. So I'll have to work with Ross to know the resources we have and how feasible it will be. At a minimum, having the zoning ordinance on the books will make sure that any new caregiver coming forward will have to abide by these requirements for site plan review and odor, security, wastewater, that sort of thing. And the benefit of the licensing ordinance is that legal nonconforming status. We can talk to the attorney about whether in their opinion, by having that language already in the ordinance about removing the legal nonconformity, if that's strong enough, then then maybe we don't need the licensing ordinance, because then those caregivers that are growing in residential are already illegal. They're illegally nonconforming. They're not legally nonconforming. They're illegally nonconforming. If that's an approach that the township is comfortable with, then yeah, we might not need the licensing. I found that the licensing is a surefire way to effectively deal with these. For example, one of the communities that first started this was Detroit. Originally, back in the day, under the MMA, it was like the Wild West. Detroit had like over 300 marijuana, medical marijuana stores, like throughout the city. And they used this approach, and they were able to get it in line, and they were able to like basically get rid of almost all of them, except for those facilities that complied with the zoning requirements and the right locations. So they were able to do that. And then now subsequently, they've eventually adopted adult use marijuana. But the licensing is the best way, but that doesn't mean it's our only approach. So yeah, we would definitely look into other means of dealing with
I
it.
think if the licensing was the best approach too, I mean, we could make it easier on the township by requiring them to, resubmit, that way the burden's on them in order to maintain their license rather than, having the township send somebody out or something like that.
Anything we couldn't handle, either way he's proposing it. The reality is we've allowed these operations for, since the initial act, what was in 2008. We adopted language shortly after that, and we've only had one approved operation that shortly got shut down for non-compliance. And, we recently had an application, but that's the first one since then. Not saying it's impossible, but I think that the people that are looking to grow, they're looking more for the commercial, or retail type grows as opposed to caregivers. It seems like the trend is dying out.
That's one other aspect of it, is that with the MRTMA, everybody can have 12 plants, and then also a lot of people that used to get the medical marijuana cards, they can just walk into an adult use facility, or recreational marijuana location to get what they need if they have an ailment that they feel is fixed with, is dealt with by marijuana. But the key here is to give you the tools, so in case something pops up in a residential district, we can definitively remove them.
Very good.
Okay.
Any further discussion from the planning commission? Thank you very much.
Thank you.
Thank you.
No new business, and we'll move to the second call to the public. Any public comment? Okay.
Okay, I'm going to read this fast. Reading comprehension appears to be at an all-time low in Tyrone Township. This comment that I'm saying tonight is generally for conservative, law-abiding, truth-seeking residents. Regarding yesterday's court hearing about Trustee Ropetta, you guys all know my relationship with him, the judge issued a written ruling. But if you've been on social media, you've probably seen the usual voices wielding their pitchforks again, out for blood, completely ignoring the judge's written words. The case was denied on the grounds of being premature. Denied on the grounds of being premature, not because the arguments lacked merit. In fact, the ruling states, nothing in the court's ruling precludes plaintiff from seeking relief from the court after he has been removed, if he is removed. So in other words, this isn't over, but you won't hear that from the people twisting the truth. What happened in the courtroom is public record. Anyone can go to the courthouse and request to watch the video. The special counsel, his behavior spoke for itself. He turned away from the judge multiple times, pointing and raising his voice at Chris until the judge had to tell him to lower it.
Could you speak to the mic, please? Thank you.
Can you hear me now? You should also know that the judge asked, had the document containing the charges ever been signed? The township special counsel said yes multiple times. Then he turned to the clerk and asked her directly, and she admitted no, it had not. Also, the document said a hearing on March 24th, a Monday, not even a regular meeting date. So anyway, they falsely claimed this document had been signed and given to Chris, which was a lie. Violations didn't stop there. Before the hearing even began, several members of the Planning Commission and the board were sitting together in the courtroom, openly discussing township business. I took diligent notes as they openly talked about Peabody's, sightlines, neighbors on a lake unhappy about special land use application, and more. This wasn't, excuse me? This wasn't casual conversation. It was business that should have been discussed in an open public meeting, not in a courtroom gallery, a clear violation of the Open Meetings Act. Then after the court adjourned, we stayed in our seats waiting for the room to clear. When we finally stood to leave, there they were, standing just outside the glass doors, most of them waiting for us to walk out. The bailiff saw what was happening and approached us, asking if we needed an escort. We hadn't asked for it, but we accepted because even she could see what was going on. And when we got out in our truck to leave, those same planning commissioners and board members were gathered again, this time with a special counsel lawyer. And so as we drove by, I recorded it with my phone. Why? Because they had formed a quorum on the sidewalk. Again, a blatant violation of the Open Meetings Act. Now, I'm sure some people are going to say I'm just bitter, sour grapes, or whatever. Just so you know, no, I'm not, because this isn't over. I'm calling out the Planning Commission and the board for what they did at the courthouse. And let me ask you all, when does the law matter? When doesn't it? We're clearly violating the Open Meetings Act, and I dare say many ethical lines have been crossed as well. So let's just see who gets outraged about what. Where are all these obvious liberal, fake Republicans, these rhinos on their high horses about what's right and wrong? Funny how easily and joyfully they ignore the rule of the law when it suits them. Now, as I said, Can he stop interrupting and I can continue?
Well, he said,
It's been past 3 minutes.
Yeah, okay, well, I'm going to finish. As I said, this fight isn't over because the law still says that good people need and can defend themselves. And so the old regime, the status quo mob, you just keep revealing yourself over and over. And one more thing I want to say. Kevin Ross blatantly taking my domain name, which expired. You could pick any domain name in the whole world. I'm asking you to do the right thing, Kevin Ross. You're pretending to be me and the watch group online, and that's ridiculous. You need to give it up and go find your own domain name. That was rude and uncalled for, and you did it on purpose. You're an embarrassment.
any other comment? Scott?
Scott Dietrich, White Lake Road. I was at the court, and I saw the video, and she repeated it again. Everything was a total lie. Total lie. I'm sorry, I was at the court. Anybody could go to the court. It was a trial against the township. She went by and videoed it. I was sitting back with a resident. We stood back from the lawyer, was explaining stuff to the planning commission members and the board members, I don't know what, we didn't have privy to it. And you did drive by, and someone asked her today, if they ever given you hand gestures, you were recording it. Play the video.
No, the attorney general.
Play the video. Casey said, play the video. Please play the video, let's see it. He called you out. Listen, hold on, Chris. I'm sorry. We work so hard on issues around here. From the beginning, you went to the attorney and asked guidance to do what you guys were doing. You threw the damn guidance in the garbage, went your own direction, and you continue to go in your direction. And you threatened these guys with saying they weren't talking business in the courtroom. Everybody you and your wife were doing fine. You sat over there nice and quiet. These guys sat over there nice and orderly. No one said, the orderly didn't take you out the door because we were disorderly. That's a small courtroom. The aisleway. Have you ever been in there? You've been in there. The hallway was jammed with people coming into court, and we were going out. They were sitting there talking to the lawyer. No one was bothering them. Chris, you know better. I've worked with you guys for a long time, but I'm not going to stand here and listen to the lies. I called Mike out for it, and I asked you 100 times, stop the attacks. It's all, I was guilty of attacks here too, but sometimes you got to take advice from the attorneys. You guys didn't. There's a process to follow, and like I told you before, you had to come to the board and then bring these guys in, okay, and then question them, okay? And come to find out, Kevin had heart problems, Steve had heart problems, so I understand why Kevin wasn't here. I understand why Kevin was here, okay? But there was issues. There's nothing wrong with asking questions. I have no problem with asking the questions. It's follow the procedures. And I got on Mike's ass for the same thing. So, I mean, but working with you guys in the past, and now I just can't sit there and tell Mike that he did wrong, and then say that you didn't. So, I mean, just don't stop with the lies, please.
Thank you. Any other public comment? Hearing none. Miscellaneous business. Any miscellaneous business to discuss? Hearing none. Accept a motion to adjourn.
So moved.
Support.
Motion and support to adjourn. All in favor signify by saying aye.
Aye.
Those opposed. Meeting is adjourned.
I think I got most of
Thank you.
the issues that I noticed on that one. Edits, but I might need you to, might ask you about it. I have some notes too, but I'm trying to go.
Yeah.
See, don't forget to sign.
Yeah, right.